Welcome back to the PI show. Before the break, we were discussing some cases about families providing care to people who are injured and how the law looks at it. Originally, the law said that if you had to pay for care, that would be compensated if you're looking at how people are compensated. But in the case of Mr. Kirkmeyer, what happened was he was a Dutch migrant. He came to Australia in 1950. He suffered a very catastrophic injury in 1972 and he ended up in a wheelchair. And after 1972, he sued his employer. It was an industrial accident. And the judge awarded past care by his fiancée and his family and future care by the fiancée and the family. He guessed a figure of what the future care was worth. And then the matter went to the High Court. It was appealed. And the defendant said that you cannot assess damages for future care because you're not under any legal obligation to pay your family for looking after you. They do it out of love, out of charity, and you don't suffer any loss. And therefore, how can you compensate someone for the love and care that a family
should provide anyway?
Anyway, as a matter of But now, what's wrong with that? How can you compensate someone for that?
Well, what they do now, it's in the Wrongs Act, our Victorian Wrongs Act, Harry. There's certain things you've got to satisfy before you can even claim it. You've got to have 6 hours of a week.
6 hours a week by a family member to care
over
for
6
you.
months.
And over a period of 6 months.
And then what they do, they calculate it based on average weekly earnings, and you divide the number of hours. If it's 40 hours a week, you divide it 1/40th per hour over average weekly earnings, gives you a rate.
But again, the question really is, why do courts and the law say that the injured person is to be paid in damages for something that
really is going out to a third person?
He could be for a third person.
Well,
so I mean, Mr. Kirkmeyer was in a wheelchair. He did need,
Well, assuming he had no family, Harry. I mean, it would be people that have to pay.
Yeah.
Mr. Kirkmeyer would have to pay nurses and doctors and whatever.
Well, that was a rationale.
So that's the rationale behind it.
Yeah. That why should the defendant who's done wrong to Mr. Kirkmeyer, why should they not be obliged to pay a full amount for all the damage they've caused, including his inability to look after himself? So,
mind you, some of these claims can be pretty big.
They're significant.
If you look at average weekly earnings being around $700 and something a week, and assuming someone's getting 6 hours a week, and multiply that over their lifetime if they do need it, it could become a pretty substantial claim.
They are big claims because they, in effect, say that if your family member's looking after you in a nursing capacity, then what's the rate of pay for a nurse, and how many hours are they doing a week? And you multiply that by 10, 15 or 20 years, it adds up to a lot of money.
Yeah.
So,
and the only thing with that is they bring it back to present values, Harry.
It's a lump sum,
yeah.
And they pay out. But, the person who's injured is under no legal obligation to pay family members.
No.
But the court says, in effect,
they should be compensated.
They should be compensated.
In some circumstances. You only get it if it's a public liability matter, medical negligence.
Good point.
And you've got to have all the...
Good point.
You've got to qualify. The qualifying...
There's now a threshold you've got to qualify.
It's got to be due to the injury sustained.
If you've got a car accident or
work
accident, the Parliament said no Griffiths and Kirkmeyer, and that's not valid law for car accidents.
However, under both acts, if you do need home help and things like that, you can apply to the various Transport Accident Commission or Victorian Workcover Authority or the agent seeking
home help.
2 to 3 or 4 hours.
Yeah, of home help.
Yeah, you get an occupational therapist.
It doesn't compensate family members who are doing it, out of charity and so.
Yeah.
Look, there's an element of fairness about it, an element of unfairness about it, but in public liability, Grives and Kirk, my
It
significant.
could be a significant part of a claim.
And the girl who was suing KFC in Sydney, there'd be that part of her claim.
Yeah, there'd be a fair chunk of it in the early days, I'd imagine, where family members got involved.
Are involved.
Yeah.
And how do you think she's going to go?
Well, Harry, the law says on a balance of probabilities, say if you see these scales, you only have to tip it that much. And I think she'll win.
Well,
Or-
we'll bring
or you-
updates. We'll bring updates from time to time. Whichever side wins, almost certainly will appeal. So,
Can I say this?
I think whichever side,
Because these symptoms came on pretty quickly.
almost immediately
Yeah.
after the eating.
If they had
episode.
been 4, 5, 6, 7 days,
Yeah.
it'd be very iffy.
Yeah.
So you can sort of link it. It's all about linking the damage to the incident of eating the chicken wrap.
the
Yep,
chicken
yep.
breast.
That's
So-
in simple language.
Yeah, so we'll wait. But look, we've got some questions from viewers. One question which I think is interesting is a scenario where the viewer says that they were riding a motorcycle and a dog ran into the road. They swerved to avoid the dog and fell off the motorcycle and injured themselves. What remedy do they have? What can they do?
If you can, well, you've got your statutory entitlements under the Transport Accident Act.
So it's a
because-
transport accident.
Yeah. You can get your medical expenses paid.
Loss of
Loss
income?
of income, 80% of it for the first 18 months, and then loss of earning capacity. But I think you're asking me about whether you can sue anyone.
The dog.
Yeah, well,
The dog's done
if
wrong.
you can identify the owner of the dog, you can generally sue the owner because there's a strict liability on the owner to ensure that the dog doesn't run out.
Escape.
Yep.
And is off a leash or
Yeah.
is able to escape. So if you were able to identify the owner of the dog, you could sue the owner for your injuries. So
Well, the owner would get prosecuted under the Domestic Feral and Nuisance Act, whatever you call it, back in 1992, I think it is, all four. And then you could sue the owner, and it's a strict liability test, which is a very high.
so the
duty on
owner shouldn't have allowed a dog.
No,
to
it should have
be-
been secured.
Yeah, to be
And
out in the
you'll
street.
win. You'll win.
So you win that part. of it.
Guaranteed.
And how's the owner going to pay?
Generally, most people would have contents insurance on their policies, home policies. You've got your house policy, you've got your contents policy, and that generally picks up public liability and would probably pick up your dog as well.
So so if the dog causes damage in this case, or causes an accident,
Yes.
you say the owner's liable, and the owner would then contact their insurer,
And would be indemnified.
and the insurer would say step into their shoes, and the insurer would be responsible for defending the claim if there's a defence. You say there's no defence. So
No, they're gone.
You'd get up, and then the insurer ultimately would pay out if the person was seriously injured. The person
And
still has to be,
and if there's no insurance and they've got a house, they're at risk.
they're at risk.
They're at risk.
But you'd still have to have serious injuries because you can't
Oh.
sue any third party without.
You'd need a serious injury under the Transport Accident Act.
Yeah, you need a certificate. You need the permission of TAC to sue the dog
Harry,
owner.
I don't want to cut you short, but you want to quickly quote for me that passage, or
Well, yeah, coming back to our first case, which was Donoghue and Stevenson, the final sort of remark of Lord Atkin, or the proposition he established as the rule, is that he says that the rule that you are to love your neighbour becomes in law, you must not injure your neighbour. And the lawyer's question is, who is my neighbour? And that receives a restricted reply. You must take reasonable care to avoid acts or omissions which are reasonably foreseeable and which would likely injure your neighbour. Who then in law is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. So that's Lord Atkin,
what a beautiful speech.
and that's his proposition about the law of negligence, and it's quoted throughout the Anglo-Saxon world. That's all we've got time for today. Any questions, send in to our website, and we're happy to sort of discuss them on air. And we'll see you next week.
Thank
Thanks,
you,
Tony.
viewers. See you next week.
Thanks.